This program is powered by AIM Employers Association and Ogletree Deacons, a Feature Group USA production.
Hello, everybody. I'm Burt Garland, shareholder of Ogletree Deacons in St. Louis. According to a recent Beltway buzz, which you'll hear about more on this program, the EEOC was quoted as stating, quote, "An initiative, policy, program, or practice may be unlawful if it involves an employer taking an employment action motivated in whole or in part by race, sex, or another protected characteristic," end quote. Strap in. I'm not getting fired up, but I might just get burnt on This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode. From the latest rulings in the courtroom to the strategies unfolding in the boardroom, and from real conversations taking place on the front lines to spotlighting what similar companies are doing about the challenges they face. This Week at Work brings you the conversations that matter most to HR professionals and business leaders like you. Brought to you by AIM Employers Association and Ogletree Deacons, live every Thursday morning. This is your opportunity to connect with their experts and ask your burning questions. So what's keeping you up at night? Let's face it together now on This Week at Work.
All right, so you all might have noticed that our friend Phil is not with us today. He's out on the AIM Roadshow. I think he's in Indiana or Florida or something like that, attending a lot of SHRM conferences this week. So we don't have Phil, but that gives us some great time for one of my colleagues, my partner in crime, to some extent, Jim Plunkett from my Washington, D.C. office, from Ogletree's Washington, D.C. office. Jim is our governmental affairs head at Ogletree. And Jim, how are you doing today?
I'm good. It's always great to be here, Burt. Always appreciate the invite.
Absolutely. We're happy to have you. I know you're an audience favorite, and it'll be really great to get an update on what's going on in DC. Everybody will recall in August, AIM has been focusing on compliance. So with the addition of Jim, this really comes at a good time. Not that I'd be worried about being able to talk for 30 minutes on my own in Phil's place, but again, Jim is a DC insider, and it'll be great having him on the program. So we know employers are balancing fairness with legal risk. This episode unpacks the Department of Justice's developments and how businesses can stay compliant. But before we get there, we're going to get warmed up with Lawyer on the Clock. Burt, are you ready to get going with Lawyer on the Clock? Jim, are you ready to join me for Lawyer on the Clock?
Yes, I am, Burt.
Nick, pull that lever.
Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
All right, so today we're going to talk about a few interesting cases out there. Interestingly, a couple of them come out of the same circuit, the Fifth Circuit, which is based down in Texas. And the first one I want to talk about is the Fifth Circuit just ruled that the Pregnant Workers Fairness Act, something that was implemented about 3 years ago, is likely enforceable in the state of Texas. And what this goes back to is a case that last year a U.S. district judge in Texas held that the federal government could not enforce the Pregnant Workers Fairness Act against Texas, the state of Texas, or its agencies. So this decision really was limited in the state of to the state of Texas, and it really only applied to the state itself and its agencies. So the Fifth Circuit struck down an injunction from that district court that barred the EEOC from enforcing the Pregnant Workers Fairness Act against the state of Texas and its agencies. And a lot of people are expecting that this battle could be headed eventually to the Supreme Court. The panel batted down the trial court injunction that had prevented the EEOC from accepting state employees' charges alleging violations of the Pregnant Workers Fairness Act, investigating those charges, or issuing so-called right to sue letters to those aggrieved workers or suing on their behalf. We'll recall that the Pregnant Workers Fairness Act bolstered legal protections for workers who are pregnant or have conditions tied to pregnancy and childbirth by requiring employers to offer them reasonable accommodations to help them on the job. So that's what the Pregnant Workers Fairness Act did. This Fifth Circuit ruling last week really has limited impact outside of Texas. Any ruling by the full Fifth Circuit wiping away the panel's decision might embolden litigants elsewhere to raise certain challenges to the law. But the practical effect is that the law is sort of already entrenched in the workplace. And to be honest with you, I think that most employers around the country had already been offering a lot of accommodations that the Pregnant Workers Fairness Act had required even before the law was implemented. And then once the law was implemented, a lot of employers, most employers had already changed their employee handbooks, policies, and it's probably somewhat already entrenched that the requirements of this law employers are still going to follow. So, Jim, you have any thoughts on this decision, just from a perspective of policy or
Sure.
what we might see moving forward?
Yeah, no, I agree with you, Burt, that most employers are already implementing this and in compliance with it. The act itself, I always joke how Congress, couldn't agree that the sky is blue. But this is actually a piece of legislation that they, as you said, they passed like three years ago, employment-related legislation, and that's a pretty rare thing these days in Washington, D.C. So there was some significant bipartisan support, Democrats and Republicans, on this bill. The employer community worked with legislators to sort of craft this bill, right? But there is some controversy around the implementing regulations, and current acting chair of the EEOC, Andrea Lucas. We might talk about her in a little bit when we talk about DEI, because she's a key player in that policy agenda. But she has some concerns about the abortion-related provisions in the regulations that she thinks were sort of existed outside or implemented outside of what Congress agreed to. She doesn't have the ability yet to change those regulations because she doesn't have another Republican on the commission. But there could be in the coming year or year and a half an opportunity, if they do get those members on the commission, for some tweaks related to the regulations that might cause some uncertainty for employers in an area that's relatively benign, I think, as you said. Like, they've sort of like figured this out. And so I wonder if tweaking the regs might sort of upset the apple cart a little bit.
Yeah, interesting perspective. I love having help on Lawyer on the Clock. When Phil's on the program, I get no help on Lawyer on the Clock. All I do is get interruption from Phil, and he makes fun of me. And it's much better having you on here kind of supporting me. So thank you for that, Jim. So not to be outdone, that panel of the Fifth Circuit, or outdoing that panel of the Fifth Circuit, I want to talk about another decision. Jim, I'd love to get your perspective on this one. So the Fifth Circuit on Tuesday of this week, that's 2 days ago, upheld injunctions barring, this is crazy, barring the National Labor Relations Board from prosecuting unfair labor practice charges against 3 companies, saying the removal protections that federal labor law gives board members and agency judges likely violate the U.S. Constitution. So this is not just applying in Texas. This could have much broader implications. These 3 companies, including SpaceX, had sued to block the National Labor Relations Board cases against them based on what they characterized as unconstitutional limits on the president's ability to fire board members and administrative law judges. So this is really a huge decision. The arguments made in the case really hinge on language in the National Labor Relations Act that only allows the president to fire board members from office before the end of their 5-year terms for, quote, neglect of duty or malfeasance in office. The president can also only remove the agency's administrative law judges quote, for good cause, end quote, after a hearing before the Merit Systems Protection Board, the leaders of which also have removal protections. There's a Supreme Court case from 1935 called Humphreys Executor versus U.S., and that upheld removal protections for members of the Federal Trade Commission that are maybe a little bit similar to those of the NLRB members. The employers who tested the board's structure in court, President Trump set up a challenge to Humphrey's executor with his January firing of NLRB member Gwen Wilcox. And so Wilcox had challenged her firing, and the Supreme Court in May paused an order reinstating her to the board, saying it was likely Trump would show that the presidents have the constitutional authority to fire board members. The Fifth Circuit majority in this case that I'm talking about on Tuesday said Humphrey's executor, that case of Humphrey's executor, was a very narrow exception to the president's general power to exercise control over the executive branch and should not extend beyond multi-member agencies that do not exercise significant executive power. So the panel said that the powers of modern board members are greater than the limited authority the Supreme Court considered in Humphrey's executor, including the authority to set representation elections, decide unfair labor practice cases, and seek to enforce orders in federal court. So after they determined the employers were likely to succeed on their claims about the agency's structure, the Fifth Circuit panel said that the companies also showed that they faced irreparable harm without an injunction. So that panel then said they have rejected the NLRB's argument that the employers did not connect their alleged harm to removal protections, saying that having to go through a proceeding before an unconstitutionally structured agency is by its nature irreparable without needing to show more. So Jim, what does this mean for employers facing unfair labor practice charges in front of the National Labor Relations Board right now?
Yeah, I think it's a little early to tell right now, Phil, what's going to happen, but it certainly potentially cuts the legs out from underneath the board, right? And it's amazing to me that the NLRA has been around for 90 years. It had challenges to its constitutionality right from the get-go that survived. And we're just sort of dealing with these new theories of the law. And it's amazing how the interpretations of the law changes. But it all goes back to this unitary theory of the executive, right? That SpaceX was sort of pushing a couple of years ago when they started this, and then President Trump has adopted. And so for the viewers out there, I think everybody understands that certain agencies, the State Department, Treasury Department, Department of Defense, those folks serve who are in charge of those agencies serve at the president's pleasure, right? So a new president comes in, we got a new Secretary of State, new Secretary of Defense. But then there's these other agencies that exist within the executive branch, like the NLRB, like the EEOC, like the Occupational Safety Health Review Commission, like the National Mediation Board, that are these sort of made up of multiple members, multiple commissioners that Congress has set up. And SpaceX, made this argument, and President Trump has been making this argument in the Wilcox case, saying like, hold on a second. This violates the separation of powers. If these guys are in the executive branch, they should serve at the pleasure of the president, right? And you can't have all these like multiple layers of protection for removal of these folks, right? So because it would violate the separation of powers, right? It violates the president's authority to operate the executive branch. So it really sort of dovetails with this Wilcox case that you mentioned, Burt. Ultimately, I think that the Supreme Court, with the members anyway, with the board members, the Supreme Court is gonna decide that. I guess they're should chime in on the ALJs, but I don't know if the Supreme Court's going to already say, hey, between SELA law and JARCASI, we've already sort of called into question the ALJ sort of format. And that goes to other sort of areas too, like, right, if the administrative law judges exists I mentioned some other agencies, but administrative law judges exist in all sorts of fashions and formats within the federal government, like hearing Social Security appeals, for example. Depending on how the wording of how they're created, this could sort of be like pulling a thread on a sweater, right? And all these,
Right.
not just the NLRB, but what happens at OSHRC, EEOC. Of course, details matter, right? The statutes matter. But this could be an interesting development in how particularly these multi-member federal agencies and ALJs are set up.
Yeah. So
and often for our listeners, like those ALJs are sort of like the first they're like the gatekeeper in a way. Obviously, you've got the investigators or the enforcement officials, the attorneys, but the ALJ is like usually like that first official, the judge that they're seeing. So this is like it could be really transformative.
It could be. I agree with you. So that I was going to cover another topic on Lawyer on the Clock, but I think that'll really help. This third topic will help us segue into our main topic of today, and we're going to talk in more detail about the DOJ's guidance that they issued last week, and then we'll let you run loose a little bit with what else is going on in DC. Sure. But first, a quick message, Nick.
Level up your HR game with an AAIM Employers Association membership. Get 24/7 expert support, exclusive training, and a network of peers. Join thousands of HR leaders building better organizations. Call AIM at 800-948-5700 or visit aimea.org today to learn about becoming a member.
So, Jim, last week on the show, I mentioned to our listeners about some new guidance issued by the U.S. Attorney General Pam Bondi. That guidance it's called, quote, Guidance for Recipients of Federal Funding Regarding Unlawful Discrimination. Now, that guidance, while it's really directed toward recipients of federal funding, it also talks about, it specifically mentions its guidance directed toward private and public entities that receive federal funds, but it specifically stated it should not just be limited to those private and public entities receiving federal funds. And so a lot of people are reading this much more broadly, that it does apply, this guidance applies to the private sector as well, even if they aren't receiving federal funds, number one. And number two, even if they're wrong about that it may not necessarily apply to private entities that aren't receiving federal funds. It certainly offers a glimpse into how the EEOC is going to be interpreting DE&I efforts. And so it's really kind of a significant development here. As we know, the Trump administration has been very focused on ridding the employment workplace of DE&I efforts. And so I'd like to get your initial take on kind of Pam Bondi's guidance. And you're on mute, just so you know. Yep, still on mute.
I'm on
There
mute.
you go.
Sorry. Yeah, no, this is a very interesting development, Burt, and this is information that's been sort of coming out in fits and starts since the administration took over, and it goes back to this basic question I think that employers have been asking since late January of this year. It's like, well, what is unlawful DEI? Like, what can I do? What can't I do? Right? Because the administration came out with these executive orders, right, and said, using that phrase, unlawful DEI. Well, what does that mean? A couple of months ago, the EEOC issued some guidance about what that could mean. And then I think this guidance issued just a week or two ago clarifies things even more. A lot of it is, I think, stuff that we already sort of could guess and figure out, but it's, I think, helpful for employers to understand the types of activities, the types of policies, the types of programs that are really going to catch the eye of the administration. And I think this is another example. I mentioned the unitary executive theory, right? This is something where, like in any other administration, I think, DOJ would have its mission, that jives with what the administration's doing. But, it's, the war on drugs, war on terrorism, that sort of thing. The EEOC would have their own mission and stuff too. But in this administration, Trump has this unitary executive theory. And so like the White House, the DOJ, EEOC, they're all in lockstep, marching together on what they view as unlawful DEI. So it's really interesting to me, this sort of like partnership in a way that DOJ has with the EEOC.
Well,
but they've as you can see here. Go ahead, Burt.
Yeah, I think that's right, Jim, and it's something that we frankly have seen building in the federal government for really the last probably 15 years. I think under the Obama administration, we started to see this with agencies, more interagency cooperation.
Yeah.
Then that accelerated under the Trump administration, under the Biden administration. It was called the whole of government approach.
Yes.
And we saw more and more memoranda of understandings between these agencies. And I think under this Trump administration, he's really crystallized it into what you call this sort of unitary theory of government, or the executive branch here. And it is sort of like one big machine marching in the same direction. And so this DOJ guidance that was released again a couple weeks ago really sought to clarify the types of diversity, equity, and inclusion practices and policies that would be considered illegal discrimination by federal funding recipients. It's 9 pages of guidance. It provides, again, non-binding suggestions on best practices. So again, that guidance really only applies to public and private employers that receive federal funds, but it is very helpful for all employers to review and understand the federal government's interpretation of the laws and enforcement policies. Now, Jim, one of the things that always makes me nervous is here we practice labor and employment law, which is really in front of the EEOC, the National Labor Relations Board, the Department of Labor. Those are the 3 primary agencies we deal with. Anytime we get the Department of Justice involved, that takes it sort of to another level because of their criminal enforcement mechanism. And so, could this DOJ guidance, or if an employer in the private sector that's not receiving federal funding, if they're following any of these practices that this guidance suggests are illegal, could that have implications for a private employer with the Department of Justice?
Absolutely, Burt. And the administration has been forecasting this since day one. They said, like, well, how do we make them, what's our enforcement tool here, right? How can we make employers get rid of what we think are unlawful DEI programs? And they've focused on a statute called the False Claims Act. And I don't know if you've talked about this at other sessions before, but the False Claims Act is a really powerful tool that the federal government uses to combat fraud against the federal government. And I usually associate it with things like Medicare fraud, where there's like people who are racking up fake invoices to the government. And then it's usually something like billions of dollars worth of fraud perpetrated against the government. Well, the administration has decided that this is how they're going to use, this is their enforcement tool for going against folks that they think are implementing unlawful DEI programs. And you mentioned criminal liability. False Claims Act has that. It also has treble damages per violation, right? So if you're a federal contractor and you're submitting invoices for reimbursement, each time you do that, it's going to be like triple damages. So these things get up really, really quickly, right? The expenses get really, really quickly. That's in contrast, like you said, Burt, like the NLRA, which has no It just a make whole remedy. It has no punitive civil penalties or things like Title VII that have caps on the amounts of damages, right? So this False Claims Act has really got the business community a little bit extra nervous, right, and a little bit more careful about what's going on here, right? And I've heard, I haven't been able to get my hands on this, but I've heard that just in the last week or so, I think probably following on this memorandum, that some federal contractors have received CIDs. It's like complaint for an investigative demand or something like that, or civil investigative demand. That's what it is, a CID. Again, we're not used to really dealing with DOJ, but this is sort of the DOJ's like precursor to a subpoena. And they're sort of been making these demands of federal contractors that they think are still operating what they call unlawful DEI programs. So there are some sort of signs that the DOJ is following up with federal contractors after this memo, after they release this memo. But I haven't been able to confirm that or see any of those letters. We've been working on it. But so absolutely, I think DOJ is going to be pushing employers on this. And listen, this is like what they think is a political win for them, the administration. I think most employers have sort of figured out a way to be in compliance with this guidance and some of the other guidance materials that have been released already. But I'm telling you, the administration would love to have an example, right? They would love to be able to have a press conference, a press release with preferably some big high-tech company from Silicon Valley or whatever that's been flaunting their instructions on DEI. They'd love to make an example of some company, right? So it would behoove our listeners to make sure that they're talking to you, talking to with their other Ogletree attorneys to make sure that anything that they're doing is in compliance.
Well, that's exactly right. And just to remind everybody, the DOJ's guidance focused really on 4 primary areas of unlawful discriminatory policies and practices. The first is granting preferential treatment based on protected characteristics. The second is prohibited use of proxies for protected characteristics. So in other words, don't try to conceal your DE&I efforts. The third one is segregation based on protected characteristics. And the fourth one is training programs that promote discrimination or hostile work environments. So it's really important that you look at your practices under this Trump administration and make sure that you are not crossing one of these 4 areas. And Jim, you have any additional insight as to those 4 areas?
Yeah, I think the training thing was like the most interesting to me too, because to me it almost seems like a subset of some of the other ones, but the fact that they sort of pushed it out as its own, the 4th bucket, makes me think that this is something that they think is maybe really a particular problem or something that really vexes them. So, this is training that might segregate people on the basis of their race, right, or their ethnic background. They're like, no, you can't be doing that, right, too. And then the other thing that I would say is anything that comes I mean, quotas have always been unlawful, right? You could never do quotas. Right. But I think that some employers got into a little bit of a gray area over the last few years. But anything that looks like a quota, even if it doesn't have a number attached to it, diverse hiring panels, right? I think that those are the 2 things that I think the administration is going to be sort of looking for the most. Anything that sort of like looks like a quota, and then this training aspect. I think they're going to really hone in on those 2 prongs of this guidance.
It's really interesting, Jim, because I've had more than one client express to me, this is not me saying this, but I've had more than one client express to me sort of the notion that DE&I became like its own sort of Frankenstein that was running rampant through their workplace. And they are almost looking at it from a perspective like they're relieved that they can now point to the law or the Trump administration's interpretation of the law to say we have to stop these practices. It was something that they had considered, that these couple of employers had considered, things had kind of run amok, taken on a life of its own, and they didn't really know how to get out of it. And now they're able to say, well, we have to stop it. And so I don't know if you're hearing anything like that in the DC area as well.
Yeah, I have, Bert. And, the interesting thing is, like, the law basically didn't change before DEI exploded, and it really hasn't changed now, right? Like, there's some executive orders, but Congress hasn't passed any new laws, right?
That's right.
And it's really just interpretations, right? And I think the administration is saying, there was that interpretation that was allowed to sort of run amok, as you said, but now we've got this different interpretation. It's a pretty sort of strict reading of the statutes and the law, but this is what it is. So I do think when we've talked to employers that and they might not have even realized that it had gotten a little bit afar, and that that they may have, even under say the Obama administration might have, if had been violating the law, right? Because they maybe did have some quota or a quota-like hiring system, which has always been unlawful. So I do think there was, it probably did balloon in a way that maybe got out of control for some employers, that they didn't realize it was happening.
Well, and what I always remind people when we're talking about this area of the law is that we kind of start with Title VII of the Civil Rights Act of 1964, which says that an employer may not use any of the protected statuses when making employment-related decisions, that you may not use those, you may not consider them. And DE&I sort of flipped that on its head a little bit. And so, again, I'm not making any policy statements here, but I am encouraging people, if they don't like this current interpretation, the mechanism really is to get the law changed, to get Title VII changed. And I don't think that's going to happen, but the way the law is written is it's supposed to be colorblind, gender blind, sex blind, religious blind, etc. And to the extent that those criteria are being considered, in my opinion, that would likely violate the law, but very carefully done, where you're taking into account that there should be no preferences, that everybody should be treated equally under the law. That's how you can sort of accomplish these goals. So I know we're running up, we're actually a little bit over time. Jim, we're going to have you back soon, because we need you to talk about sort of what's going on in DC. Maybe we can get you back on a program here in the next couple weeks, because I know our listeners want to hear all about the latest in DC. So Nick, you had something you wanted to close out with, I think, and then we'll be right back after that.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.
All right, so don't forget to download the Ready, Aim, Fire cheat sheet. Don't forget to register for the 2025 employment law update put on by AIM. Part 1 is going to be this legal update that I'm participating in. And one of my colleagues from Indianapolis is also participating, Justin Allen. That'll be on September 17th from 8 a.m. to 12 p.m. Part 2 will be a policy workshop with coaching. That'll be on October 1. Learn about becoming an AIM member at AAIMEA.org. And Jim, I can't thank you enough for appearing on the program. Hopefully you'll come back very, very soon so we can let the audience, and maybe we'll give you a whole 15 plus minutes to talk about what's going on in DC. So I appreciate.
I'd love to be back, Burt. Thanks for having me.
Thanks for your time. Don't forget, everybody, go out and be good to somebody.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please like it, share it, and make sure it's on your calendar every week. Ask your burning questions anytime and let us know what topics you'd like us to cover. Just go to hrask.org and be sure to leave a review wherever you catch our show to help other HR pros find us as well. We'll see you next week when we discuss what's happening this week at work.